way to create a roadmap for the future generations in continuance of celebrating 50th Golden Jubilee year of Law Center 2. Today we are having one more event in our Golden Jubilee celebration Delhi two has and this day is not the law. University of Delhi. Law Center founded in the year of 1961 at of because those to a while offering full-time program. Today, Center 2, we have done that 2021 it must be a massive center to the quality research. The for disturbance. Again, am I audible or not?
Yes, you are audible, sir. You are audible now.
Okay. Okay. So it is known for the quality teaching, research, and other co-curricular and extracurricular activities. Center is a hub of research and learning for law students, promote students' activities at the center. A number of committees have been constituted, like moot court, debate and seminar committee, journal committee, legal aid committee, placement committee, and alumni committee. The center had place of being headed by the top law scholars of India, such as Professor Upendra Bakshi, Padam Shri Awardee, a well-known jurist and former Vice Chancellor of University of Delhi. Professor Tahir Mahmood, who subsequently became chairperson Minority Commission, Professor A.K. Kaul, who was elevated as Vice Chancellor NLU Jodhpur, NLU and NLU Ranchi. Professor Gurdeep Singh, who became Vice Chancellor NLU Kannauj. Professor B.T. Kaul served as the chairperson Delhi Judicial Academy. Professor Poonam Saxena is presently Vice Chancellor NLU Jodhpur. Law Center 2 has the privilege of having alumni from all walks of life. As Law Center 2 is celebrating its 50 years of teaching, the center has grown exponentially in footprint, academic offerings, student body, to number of alumni of Law Center 2 of India. The alumni included senior bureaucrats, police officers, revenue officers, doctors, engineers, chartered accountants, company secretaries, politicians, etc. Some of these alumni includes His Excellency, Honorable Governor of Arunachal Pradesh, Brigadier Sri B.D. Misraji, Sri K.J. Alphonse, Member Rajya Sabha, ex-ministers for state, this the Justice Kailash Gambhir, Justice and Dhingra, Justice Rajiv Sakdar, Justice Y.K. Rao, M. Damodaran, ex-chairman of SEBI, Mr. G.D. Gay, Mr. Manoj, director, Indian Law Institute, New Delhi. Many more legal luminaries. Law Center 2 has been publishing two journal named National Capital Law Journal and Daily Journal of Contemporary Law, publishing quality research papers in the field of law and contemporary issues. I feel to be closely associated with Law Center 2. My dear students, colleagues, non-teaching staff, everyone associated with Law Center 2, we have crossed the zigzag path of thousands through mile and tenacity. And today it's time to celebrate, to introspect, and consolidate, and to plan for Law Center 2's future. And today we are having on the celebration or on the celebration of the Gold Jubilee, we are organizing, our organizing team is organized this seminar on feminist, feminism and feminist justice. And, and today we are having speaker and scholar, Professor Akhilendra Kumar Pandey. Professor Pandey, who is from Faculty of Law, Banaras University, Varanasi. He graduated in science from Faculty of Science, BHU. His LL and LM from goal together in LLB and complete the honor of PhD. I know him very personally, Professor MPC. His area of specialization, criminal law and criminology. And area of interest is legal philosophy. His teaching career in 1990, Sikkim Government Law College, Gangtok, and served in University College of Law, North Bengal University, Darjeeling, 1990. Professor Pan supervised 4 scholars fully and 6 sergeant wrote and 45 dissertation. Professor Pan earned 2 years of teaching and experience. Took on state of affairs of members of police personnel in Varanasi district with the Bureau of Police Research and Development, Ministry of Home Affairs, Government of India, New Delhi. Is Society of Criminology and member of school board in Central University of Sikkim, Gangtok, Sikkim, Assam University, Silchar, Assam, Mohanlal Sukadia, Udaipur, Rajasthan. He is a coordinator of legal cell BHU and associated with various committees of BHU University. Mr. Pandey, our teacher, because of your scholars, our teacher, as well as our students, are very much enthusiastic to hear you on this burning topic. So I won't like to become impediment between you and them. So I welcome you from the core of the heart of family of Law Center 2. And now I invite you, I request you, request our work.
Oh, well, thank you, sir, for the welcome address. I will now invite Honorable Chief Guest, Mr. Dr. Kalain Pandey, sir, to please take over the floor and address us.
Uh, Thank you, Mr. Nilav Ranjanji. At the outset, I am thankful to Professor Dr. Mahavir Singh Roji, director of the program, Madam Pinky Sharma ji, and the program coordinator, Mr. Pramod Tiwari, and the members of the organizing committee, that they have given me the opportunity to share with you some of my thoughts on this particular topic. And I am thankful to all those who have spared time to share with me this evening on a topic which is of interest, because at least it is touching the issue pertaining to 50% of the Indian population. So I am thankful to the advisors, I am thankful to the audience that they have given me the opportunity this evening. The topic which I have chosen for today's deliberation is feminism and feminist justice. The issue pertaining to women has been treated on a path which has not been very comfortable. Rather, many ups and downs have been there. And same thing happened with the word feminism. When we use nowadays, when we use this term feminism, we very easily understand that what feminism is. Anyone can say that issue pertaining to women that may be brought in the domain of feminism. But in fact, if we go by the history of this term, it was used somewhat very certain manner, I should say. For the first time, this word was used by a medical practitioner of France in 1871, who used this term for the purpose of showing that man who has developed character very much similar to that of a woman. So it was a kind of feminization of body of a man. In that respect, the word feminism was used. Subsequently, when this word was used, it was used referring to those women who were behaving and portraying themselves as if they were men. That was a kind of virilization of women. So courage shown by the woman was called feminism. The word feminism occurring in the Oxford Dictionary in year 1900, so it came into by 1821 and it 1772, but for the first time it appears in dictionary, Oxford Dictionary in year 1901. Feminism is connected with women or deal with women. This concept of feminism, in fact, it is a social concept. It is a political concept. It is a concept given in literature, and very late, sometimes in the 8th decade of 20th century, it started gaining ground in the area of law. So legal feminism, it enters very late. But so far as the discussion pertaining to women issue is concerned, that has a long history. That time was 1864, when in a town of New York, Seneca Falls, the convention was organized. And that convention was dealing with the rights of women in culture, social, and religious. And they were talking about equal rights to women. So the available document shows that it was the Seneca Falls Convention in 1864, where for the first time a movement started that women should get equal opportunity to that of men. Over a period of time, this concept of feminism, it took various versions. But before we come to various versions, it becomes very important to understand that what is center of discussion so far as feminism is concerned. Or in other words, you can say that what are the inquiries in which feminism is interested. Now, if we say that what are the important inquiries which the feminism seeks to explain or find out, then can see that there are three-pronged inquiries. The first prong is dedicated to describe the nature of subordination of women. Describe that where women is under subordination of man. The second prong of feminism is dedicated to understand why, by what mechanism the woman is subordinated, what is the reason of subordination, how woman is subordinated, and why she is subordinated. That is the second aspect which is to be probed by any feminist scholar. And the third one, that how this situation can be improved or changed. If see inquiries, it's very clear that they are very much focused that what they want to see. They want to understand the nature of subordination of women. They want to know how this subordination is perpetuated and what are the reasons, social, religious, and other reasons, which are responsible for perpetuation of subordination, how the situation can be changed. So, on this particular point, Catherine MacKinnon has said that the purpose of feminism is to raise consciousness among people. It is at least human concept that there is a problem pertaining to women and those issues must be analyzed. That is the conception of feminism given by Catherine MacKinnon. There is a scholar who is named by Annie Rich. Her full name is Adriana Rich, but he is known by Annie Rich. Adriana Rich has said that its purpose is to change, revise the system, structure, and the nature of subordination of women. She says that change is very important. We should go for change. This kind of relationship between man and woman should not continue further, where subordination, subjugation, and exploitation has come manifest. And at one place, she has also mentioned that it is not only a chapter in the history of culture, rather, it is the matter of survivalship. So, according to her estimation, the woman will not survive unless until feminism gets its true, true space in the area of epistemology. So, feminism is important method of study also, where inquiries are made keeping in view three prongs, which I discussed just now. Now, this one author lad, he has mentioned in his book, textbook of jurisprudence, that feminism is a concept which can be compared with a house. It is a kind of fort in which many rooms are there, but all the rooms, they connect to one particular point, and that point is that woman is put under subordination, and all the social institutions, they are patriarchal in nature, including law. So this prism, it seeks to understand that why woman has been put under subordination in every kind of epistemology, in every walk of, in every discipline, including law. So law is also masculine, law is patriarchal, law is male. This is the condition of the feminist. And this statement of Lloyd that feminism is just like a big house in which there are many rooms, certain versions of feminism emerge. And as Pramod Tiwari ji has very rightly pointed out, that one version of feminism is liberal feminism, or it's also known as individualist feminism, or also known as classical feminism. The second version is, in fact, derived from Marxian concept, and that is known as socialist version of feminism. Third version is of radical feminism, and fourth one, which has come very recently in vogue with the use of predominant use of postmodernity almost in every discipline. Now, if we see that what has been the contribution of classical or feminism, in fact, it is based on the premise that be it man or woman, they are endowed with the same qualities. They have got reason, they have got autonomy. And the premise is that if a male is having low IQ, does not mean that he is not a man. So if it is said that woman has got no reason, no autonomy because of her low IQ, that does not hold good. She said that the nature has bestowed the species, that is Homo sapiens and man, autonomy and reason. That reason and autonomy is must be made available to every man and every woman. It is also arguing that gender is constructed by the society, while sex is determined by nature. So if the society is deciding the gender, society can also control certain activities. Society can confer certain rights. So, for biological determination of sex is concerned, that is left with the nature. We cannot do anything with the help of or institutions. So the prime emphasis has been that man and woman, they are born equal with equal capacity and propensities, and therefore there should not be any kind of distinction and differentiation. Here, if you see United Nations Convention on Elimination of all forms of discrimination against women of 1979, it can be said safely that this convention was predominantly based on the contribution of classical or liberal feminism, where they are equal right that of men. So women started entering every domain of social life, be it politics, be it education, be it any profession, lawyer's profession or medical profession or engineering, whatever it is. And the impact of this can be seen when the Supreme Court of India decided famous case of where severity to women, particularly married women, that was done away with by the Supreme Court. I am not interested in touching the cases decided by the Supreme Court. I am more interested in having discussion so far as concept and idea on theoretical platform. It might have been rejected many times, it might have been accepted many times. That is not the prime issue. Prime issue is that how the issues pertaining to the woman have been tackled by various versions of feminism. So there was a time when the woman was not permitted to enter in the domain. It was confined only to house, and therefore there was a need to argue for equality in every sphere of human life. There are many thinkers in this series. I am not going to touch that issue. Now the another one is of a socialist world or socialist feminism, who say that woman cannot become equal to that of man unless and until she is empowered economically. And it believes that this system has been in such a manner that woman has been put to all the hardships, but the real fruit is enjoyed by the male. So women should also be permitted to work, should be employed, and until she becomes economically empowered, it will be difficult for her to sustain equality in this system. You can say that if Marx was emphasizing upon class character of law, socialist feminism is interested in making law as gender. So class is gender. The law makes discrimination between two genders. So economic empowerment is essential. And the effect of this was that under Indian Constitution, the provision for equal pay for equal work in the Constitution, and followed by a legislation named Equal Remuneration Act 1976, that man and woman, they should get equal remuneration. There should not be any discrimination in remuneration. Prior to this act, if work was done by a male, for 8 hours, he was entitled, suppose, for 10 rupees. For the same duration of work, for the same work, woman was entitled to have only 5 rupees. So this kind of discrimination was there. So the impact of classicals along with the socialists was that woman was brought in the area by which she could develop the economic empowerment. The second important is that social feminists, they argue that man has is constructed the society in such a way that has which man and male involved. Reproduction has been kept out of this domain. Reproduction is also one of the important factors for which woman is responsible to a great extent. But reproductive concept has been taken away by calculating GDP, GNP, etc. So production and reproduction, this dichotomy should be done away with. As much as production is important, similarly reproduction is also important. Woman is doing work for longer duration, maybe in household chorus, but that contribution to the society is not taken into account. But where man is involved in production, he is working in the factory, that will be taken into account. So socialists, they are arguing that unless and until woman becomes economically empowered, the equality can never be achieved. So as radical feminists are concerned, radical feminists, they are arguing that it is impossible to treat man and woman. The society did not give one word to woman independent of man. Well, society cannot confer right to that woman. Their emphasis is on the issue that woman is always defined with reference to man. W-O plus M-A-N. So man with womb is a woman. She could not get in independent word. So if the society could not give this word, then how we can expect? Therefore, the radicals, as the name suggests, they argue that the traditional role which woman is supposed to play in the society, that traditional role should be done away, should be discarded, should be rejected. So they disregard, they reject the concept of heterosexual marriage, that they will not procreate, they will not marry, thus they will not procreate. And they go to the extent that the distinguishing feature between man and woman is the womb. And if womb is removed surgically from the body, then that body will get the shape of man, and she will become equal only when that womb is surgically removed. If it is so, then it may argue that what will be fate of mankind, the perpetuity of human race, that may suffer. The other version, or it can be called as cultural version of feminist, is that there should not be any distinction so far as the cultural behavior of men and women is concerned. Man can take drinks, woman can equally drink. Man can smoke, woman can smoke. And the trousers and shirts which a man is putting on, the same can be done by the woman. So they should behave in society such that there is no difference between man and woman. And because of the impact of that, a new kind of society developed, and particularly with reference to unisex apparels, maybe t-shirts, maybe trousers or jeans, whatever it may be called. Now there is no distinction on the basis of which man can be distinguished from woman. Sometimes it makes confusion whether a person moving on the road is a man or woman because of that cultural impact or that radical impact of feminism. Because it was extreme, it could not survive for long. While the classicals and continued for some, it is still continuing. Shape might have changed. Now, so far, the fourth one, that is postmodern. Regarding the use of term postmodern, one thing thing should be made very clear that when we add word gives an impression as if it is after modernity. It's not like that, not like after modernity. Rather, the post word in modernity has been used in a sense which is alternative to modernity. So post-modernity, it attacks on the modernity. They say that modernity had promised that it will improve the condition of human life on the basis of certain meta narratives or grand narratives, standing on three important pillars of equality, of rationality, of universality. Equality, rationality, and universality, these were the three important pillars proposed by modernity. And on the basis of these three, the entire world will change. That was promised by the person who argued for modernity at one time, particularly in 17th and 18th century, with the advent of René Descartes, Leibniz, etc. But post is saying that modernity could not improve the condition of man. Instead, objective power has eliminated man from man. It has given illiteracy. And because it could not fulfill its promise, therefore time has come that we should go for an alternative to modernity. Or you can say that post-modern is very modern. Binary is 0 and between these two, entire computer system is based. So modernity is one aspect and post-modernity is the other. You can say that it is just the opposite. Now, what can be the opposite of equality? It is difference. Can be what can opposite rationality is emotion. What can be the alternative of universality? It is particularity. So postmodernity started gaining its ground in the late, or you can say almost in the same time when the feminism was spreading its tentacles throughout the globe. And equality was replaced by difference. That feminists, they are saying that all women, they are equal. Throughout the globe, the problem of exploitation of women exists. So they should be united together. That is their concern. All women, be it white middle-class women or a Negro woman or Indian woman, they are having the same problem and therefore they should be united. That was the conception of classical feminism. But postmodernity says that no, the condition of women throughout the globe is not the same. We said women are having the same problem of subordination, exploitation, and subjugation. Then the postmodern thinkers, they differ. They say that a black Negro woman is not very much perturbed with the white male. Rather, her biggest enemy has to be white woman. That is the mistress. So at times, man is not the enemy of woman. Rather, woman is the enemy of woman. Take simple example that if you analyze the cases on dowry prohibition or dowry death cases, you find if 10 persons have been implicated, then 6 to 7 would be women and 2 to 4 will be men. So this contention gains ground or has some substance that it is not always good to presume that cause of exploitation, subjugation of women is the male and male. That there is no antagonism, cannot be antagonism always. The enemy of woman is another woman, and the Negro woman is having different problem than that of a white middle class woman in America. Similarly, in India, the woman in Delhi, Bangalore, Madras, Calcutta, Bombay, Bangalore, their problems are different from that of the woman living in the tribal area. So how can we say that all women, they are having the same problem and therefore they should be united? So equality is replaced by difference. That we are tribal, we should be treated differently. Then reality is replaced by illusion. I think that many of you as participants are not more than 25 or 30 years of age. But if you are interested in old movies and literature, then you can find that every literature, it tried to give some message to its readers, be it in the form of poem, novel, stories. Every literature, it tried to give some message. Similarly, movies which were produced in those days, modern, they all try to give some message to society, maybe against feudalism, maybe against capitalism, but some kind of message. But you see the movies made particularly after, you can say that movies accept the characters are good. They have done tremendous work. The music is very good. Scenic beauty is very good. But if one line question is put to you, that what kind of message this film has given to you, perhaps it will be very difficult to come to that. Reason, it is full of emotion, and emotion cannot be expressed in words. It can be felt. At the most, you can say the movie is good, music is good. So reason was replaced by emotion. Man has become much more emotional than rational animal. At one point in time, it was said, man is rational animal. Now we say in postmodern era, man has become an emotional animal. Now, the third replacement was universality by particularity. I cannot treat myself with those of other person having different places. I am an individual. My grievance should be addressed at priority. Sometimes this kind of question is raised by the student when they are looking into their examination papers. Sir, you have given me less marks. Why? The teachers usually explain that why he has been given less marks. He said that, yes, sir, it's okay. Whatever you are saying, that is not there, but at least I have written something there. So you should be concentrate on that point. Means man is emphasizing now on individual. He is not looking to university that what they have done is better in comparison to that. So there is one famous advertisement also, tomato Maggi ketchup. I do not know whether that advertisement is still on or not. But tomato Maggi ketchup is different. It is not like any other. So it separates the concept of equality with difference, universality with particularity. Now, when we apply this concept in the area of feminism, I will request Mr. Pramod Tiwari that we started about 6:20. So you give time up to 7:15 at least. Is it okay?
Okay, sir. Okay, thank you. Thank you, sir.
Okay, thank you. Thank you. Though I will try my level best to conclude before that.
No issue, sir.
I need
No issue, sir. Take your own time. No issue, sir. No issue at all.
Okay, sir. So when this concept of postmodern was applied in the area of feminism, so postmodern feminist thinkers, they say that we have to find out where law is permitting and where law is enforcing. sterilization of women body, where law is perpetuating, enforcing maternalization of women body, and where law is permitting and perpetuating the sexualization of women body. So if we can deal with the issue where woman's body is perceived as an object of sex, where woman's body is perceived as a body to procreate and perpetuate the human race, and woman's body is put to terror. What are those areas in law which is permitting and which is enforcing? If the study can be made on these counts, then that study can also be called as study. Therefore, feminism is not only it is a concept, but it is a method of study also. Feminism is a method of study. It is based on objectivity. It is not only limited to heuristic idea. Postmodernity says that women should not be governed or should not be influenced by the fact that man is the enemy, number one. Number two, that is try to see where law is an instrument which is permitting and perpetuating sexualization of body, materialization of body, and the right of woman body. If we could do away with, then we can say that equality to the woman can be achieved. Now, after having this, we will enter into another segment of our discussion, that what is the concept of justice according to Feminist. Hitherto, whatever we have discussed, that was pertaining to describe the nature of subordination of women, the law as an institution which permits and perpetuates, which is the social institution responsible for making women subordinate to that of man, and they are arguing that it can be changed. But if when we come to the justice aspect, without going into the various facets of justice, because this concept is dynamic in nature, it is having protean shape, I directly switching over to version of justice. Now, if we say that what is the feminist version of justice, then for feminist, it is Rawls' theory of social justice, which is the center for attack. The first foremost thinker, feminist thinker, happens to be Okin, who says that, okay, the social justice concept given by Rawls, that there should be distribution of primary goods on the principle of equality, that's okay. The point is that right injustice is being perpetuated in the domestic life. So Rawls' theory of justice can be valid so far as public life is concerned, but it does not penetrate into domestic life. That is the biggest problem with Rawls. On that, Okin is sympathetic to Rawls' conception of justice, but at the same time, she says that no, your theory does not give justice to the women inside the house, and therefore your theory is not of universal application. So she has discredited on this very count. Second important thing happens to be Carol Gilligan. Carol Gilligan is writing a book named In a Different Voice. Whatever she has given in that book, that indicates that there are two kinds of ethics, and these are based on gender. One is ethics of right and justice, and another ethics is ethics of care and relationship. So far as ethics of care and relationship is concerned, it is well, it is for women, and care and ethics of right and justice. It is the ethics for men. What is the basis for making this distinction? It is said that if self is made detached from the other world, then the moral, then the ethics is of right and justice. But the moment one is connected with other, then there is an element of ethics which is based on care and guardianship, care and relationship. So for women, it is care and relationship that matters, and for man it is right just that matters because of their perception about the connectedness or detachment. It may be said that what Carol Gilligan is arguing is suggesting that because woman is making care of her, maybe children, maybe husband, or members of family, and therefore she should prefer to stay back. Few days back, someone, maybe a political person, the best place for the woman is to stay inside and go for cooking, taking care of them. But I think is that it is also suggesting that women should come more in public life if it is viewed from the other angle. Then what Gilligan is suggesting is that there should be more participation of women in public life. Is there. But important thing comes from a book written by Kate, what is now, the name of the book is, I am missing the name of the author, I am coming to the point. The name of the book is Sexual Contract. Carol Pittman, the name of the author. She is saying that in fact, whatever Locke has said in his theory of social contract, the genesis of subordination lies there. Now, if you go through Locke's constitution, though he's talked about equality, etc., liberty, etc., but at one place he has mentioned that there should be two kinds of education, one available for boys and other for male. One is for Emily and other for Sophie. So for mathematics, astrology, physics, astronomy, physics, all these are for man. These education should be given to man. And to woman, cooking, rearing of child, knitting, taking care of household work, that should be the area of education for women. So it has not discrimination. What Patman is saying is that when Locke was conceptualizing his concept of social contract, he was trying to say that king is political. He is not paternal. So political and paternalism was made to be distinguished. King is a political entity and he should confine to that. He should not behave like a paternal figure. So he should remain that. In other words, you can say that from this particular social contract, the concept of public domain and private domain arose. And public domain was given to man and private domain was assigned to woman. So to Carol Patman, marriage, subordination of women in marriage was a necessity as well as it not only necessity, it was necessity and it was the natural effect of social contract theory, by which woman was made subordinate contract that will come in public domain and one will remain in private. So public and private domain dichotomy started with the Lockean concept of social contract. So there is a need that paternalism should be separated from public, that is political, political thing that was not taken in that context but acquired with a different shape and content, and woman was sent back to the domestic area. Now, when we discuss about Russian conception of justice, based on the principle of equality, and same has been argued by his scholar Robert Nozick in a different context. But what has been the central issue to a feminist, that man and woman, because they are endowed with the same qualities, so far as the autonomy and reason, mental peace, there should not be any discrimination between man and woman. Now, this approach has been called as escalation approach, where woman becomes man, then only she will get the equal right when she starts working in the public area. For participation, I said Mr. Pramod Tiwari has given me.
Please go ahead. Please go ahead. We'll take up the question and answer later on.
Okay.
Yes, sir.
So let me complete. I will be completing it within 10 minutes.
Yes, sir. No issue, sir. Please go ahead, sir. Please go ahead.
So this feminist assertion of justice, that woman will be tied to equality only when she will become or she will start acting like a man, that was objected by many feminists. And here comes the contribution of Iris Marion Young, who wrote a book, Justice and Politics of Women, in year 1990. There she has said that it is not appropriate to accept the Rawlsian concept of equal distribution of primary goods. Simply distribution of primary goods on the principle of equality, that is not going to do justice to the women. Rather, it is a mistake that distribution is going to do some justice to women. It would be appropriate that if we could eliminate from the institutionalized system which perpetuates oppression of women, institutionalization of women, of oppression by various means and methods against women, that should be discarded. And therefore, she is arguing for a different approach in which she says that equality where it is essential and difference where it is equal. So it should treat with equality with difference. And she says that unless and until we identify the facets of operations, we will not be able to do justice to women. And therefore, a new kind of justice from women perspective emerges with her contribution. She says that there are 5 facets of operation. These 5 facets are exploitation, then marginalization, second one. Third one is powerlessness. Fourth one is, and fifth one, last is violence. Now she says that exploitation is attached to some economic concept. That in exploitation, what happens? The benefit of labor of one group, that is treated as process. that shift to other. Same thing was argued by Karl Marx that the benefit of the laborers that goes to another class, which over a period of time becomes bourgeois, capitalist, and the proletariat or the workers they suffer. So whatever benefits the proletariat created, that is very in a very steady process that is transferred to other class. So here, Iran Young has replaced the word class by sex. Take simple example. Yes, I am very much mixed. Argue for equal opportunity to men and women, and I permit my wife to go for work. She is in service. But when she gets her remuneration, can we say that she is having 100% control over her purse? But not. So what Young is saying that the burden has been imposed on the woman and the fruits are gradually transferred to the man. If this kind of some perpetuating the society, then by equal distribution of primary resources is not going to do anything to a woman. The second aspect, that is marginalization. There are many issues which are kept aside. Why? Because it is not very much relevant to the society. I would like to share one view with you, one example with you, that we do not have any provision in our Indian Penal Code even today that a man has made a promise to a woman that he will marry to someone in times to come, and thereafter he refuses to marry. Whether such conduct on the part of man should be treated as sexual assault under the definition or not. We say that there is no provision. If the man could marry, and it could be shown that he never intended to marry, he may be held liable for offense of cheating. But so far as offense of sexual assault or rape is concerned, he will not be held liable. So on this particular issue, woman has been marginalized because her case is not taken into account by law. Third one is state powerlessness. If the woman is powerful, she gets a reputation, she gets status in the society. But in case she is not, then she is viewed with different angle. Take example of Shobana Bhatia, Indira Nooyi, or Ruby Shah Majumdar. All these personalities, they have acquired great place in their life. So society looks them with pride. But if the woman is powerless, her position in the society is bad. Then the fourth one is cultural imperialism. And more the time, the power to define the conduct of other lies with the man. Whatever man is saying, that should be accepted and obeyed. So man will define what woman should do and what she should not do. Most of the times, substantial number of times against women are committed because of this thing. It is the definition given by the man. And if this kind of society is perpetuating and continuing, we cannot think of justice to women. And the last part is, if violence is perpetuated against women, be in public place or inside the house, in domestic spheres, and through violence, woman is tamed. It is said that she is being tamed by this punishment, this violence. Then justice to women cannot be perceived. In recent past, Supreme Court has given verdicts. I would like to name a few. That when Sabarimala case was decided, it was said that it was a great win for women because it has given a right to enter in the temple of that deity who has made prohibition on the entry of women belonging to a particular age group because of their biological conditions. So that was a great achievement. But ultimately, what has been done? It has been referred for review. So that right has no sense, no meaning. Sarah Bano case, it says that by denouncing triple to process of legal instrument that has given equality and freedom to women. It's true. But do you think that by punishing the husband of that woman, that will be a real justice to the woman? Better for question. When the Supreme for the first time declared that a woman, a Muslim woman, who has been divorced by her husband will be entitled to receive maintenance so long as she remains unmarried. In famous Shaban, that another patriarchal that her right to receive maintenance will be available only to the period that is after she will be exonerated from that right, or she will not be entitled to that right. So what kind of right conferred over a period of time at women? That also is a matter of discussion and to be analyzed from the feminist perspective. So this was somewhat a stray idea which I wanted to share with you. I know that there may be many questions on this issue because from gynocentric approach, we are moving again back to androcentric approach, where in feminism it is the woman who is kept at the center, but in the androcentric system we put again man at the center and we start talking about it. Now in this connection, my session is that law simply gives create space for women to get redressal from the system. But if this space is destroyed, damaged, misused, abused, this space can be lost at any point. I would like to remind you that 298A in the Indian Penal Code was introduced cruelty against men. But once it was found that this provision is being misused by men, the matter was referred to the Law Commission to give its opinion, to solicit opinion of and it's possible that 498A should be recommended for deletion from the Indian Penal Code. So point is that law is simply an instrument which can give a better service. But once the instrument is misused, certainly that instrument has to be dismantled. So there is another approach, an androcentric approach, that is coming up in a big way, particularly when women started misusing these provisions of law based predominantly on feminism concept in the area of sexual harassment at place, or levying false accusation against men in mean cases. That has given rise to an occasion to give a thought once again that whether this misuse of provision of law should be addressed at this juncture or it should be deferred for a time. With this, again, I am expressing my thanks to organizers. They have given me the opportunity to share my some straight thoughts with you and have a very good evening with all you people, having the company of you people in this evening. So thank you very much. Thank you.
Thank you, sir.
Thank you, Pandey. Thank you. Lot of thanks.
Thank you, sir. Thank you, sir. Sir, such a vibrant discussion and such an enlightening session for our students. I think from your lecture, student of all the three centers and student of different part of the country of legal fraternity has been definited a lot, sir. Thank you a lot for such a
Thank you, sir. Thank
now, Yes, sir. Now this is question. This is the time for question and answer. So this is my request. If anyone interested to ask the question, may ask. Now Sunit Kumar, Sunit Patak. Yes, you can ask the question now, Sunit.
Good evening, sir. Sir, my question is related to topic today, and that would that there are very good laws for protecting the rights of women, and I personally feel that it should be there. But as you have mentioned that many women try to misuse these laws for their own gain, due to which these laws are getting diluted by the day in the courts also. So what is happening is like I have a mother. So tomorrow if I have some genuine issues, what about the women who have genuine issues? And likewise, many women who have genuine issues. So what about them? So how can this thing be addressed? I have no issues. Like I'm really grateful to our legislature that these laws are in favor of women because
Sunit, precise.
yes, sir. My question is that if the laws are being diluted, what are the women who are really facing difficulty?
Okay, Mr. Sulit, I will take up your question. Thank you very much. And your question is good and pertinent also. That has created space in for a few. If then, in sufficient number, they are misusing the power, they are misusing this arm, then certainly a time may come that we have to ponder over, we have to think that why not this kind of instrument be withdrawn. It is given space. That space should be used when it is essential and necessary. And if it is being misused and abused, certainly that instrument can be withdrawn. I would like to share with you, because you have raised this question. At one point of time in Scandinavian country, I think it was Finland, when marital rape was being acted, it was argued that the women will misuse their this provision for their own benefit. But to utter surprise, the history of 150 years or more than that does disclose a still situation where women use. So if the citizenry is wise, they are vibrant to the cause of women, then certainly it. But if they're interested only for petty benefits, arriving at one point of time or the other, then certainly entire that will suffer. Entire woman group will suffer. So that's why I submitted that though feminism has made an attempt to give a substantial right in favor of the woman, but they should not go for its misuse and abuse. Otherwise, anything may happen as the Supreme Court had stated that not we should give it again on the withdrawal of Section 498A.
Okay, sir. Thank you, sir. Now, Arjun, please keep on your camera. Once you are asking the question, please keep on your camera and introduce yourself. You should ask the question.
Dr.
Yes.
Good evening, sir. Actually, I have some sort of problem with my camera. There's some technical glitch. I owned it, but anyway, sir, I'm coming to my question.
You are audible to me. You may put your question.
Yes, sir. Sir, first of all, thank you so much for this enlightened talk. Sir, my question is related to real aspect. Sir, considering the dynamic nature of society, I mean, from 17th century to this 21st century, the society has changed tremendously. So, considering the dynamic nature of society, why legal machinery is still mechanical in nature? I mean, my idea of justice related women still seem a long way off. For example, just a few days back, a recent development in USA related to abortion law, or you just mentioned that the Sabrimala case. So why the legal machinery or lawmaking machinery is still not up to with the society? Why they are not considering the society aspect related to women or feminists?
Okay, Mr. Arjun, if I could take your question in right perspective, I would like to say that nuclear power generation would have taken place much earlier, but it is not. So as and when need is felt by the society that this kind of behavior should be controlled, then only the question of legislation arises. It is true that society moves faster than the institutions, but at the same time, legal institutions they do not ignore the development taking place in the society. So let the society grow because society is just like an organism. It develops, it grows, it matures, and ultimately decays. So, so far as the institution is concerned, it is always waiting for that stage when the problem becomes very much manifest and there is a need for intervention. Then only, otherwise it is left with the freedom and liberty of the individual. That's why you can say that law does not intervene.
Yes, Nilab Ranjan.
Yeah.
Nilab Ranjan. Yes.
Yeah, well, thank you so much for the interesting address. My question is the recent debate on the marital rape and the judgment which has been pronounced by the Delhi High Court. My question is, I'm not debating against or for the marital rape, but how will you provide the evidentiary value to what is happening and whether it is consensual, what has had happened in the bedroom of a condition in our act, or do we if or if marital rape is legalized, that then we do we have to that does the parliament have to come up with some new legislation into it? That's my question, sir. Thank you.
Okay. Uh, as I told you earlier, that when in Sweden this marital rape was criminalized, opinion was expressed that everyone will be behind bars after some time. Because if woman has spoken something against her husband, then there will be no independent evidence against in order to prove the innocence on the part of the husband. But that not happen. My point is that even today this society is not so developed that this should be criminalized. If we reach to that level of ethics, a woman will not go. Though it is presumed that woman will not take a statement, affect her dignity and her sexuality, but it is not the case. When capitalism is growing too fast, man is running after money, and you must be coming across in newspaper almost once in a week. A woman got married, and what the property was, mobile property was the husband, it took and escaped, absconded. What does it mean? Point is that whether the society is mature to that level that we should go for criminalization of marital rape. Of course, autonomy is there, mental attitude approach is there, is there. But whether or not that should be conferred at this stage of maturity of that. So unless and until there is raising of a moral consciousness of the people, we should not think about that. Theoretically, it is good that woman has equality, she has equal freedom, she has got autonomy over the body. It's okay, but at the same time, if it is being misused, the likelihood of being misused, as we are witnessing in the cases of sexual harassment of women at workplace, makes nowadays, even Delhi also, where a woman reported a case against a man, and that resulted in ultimately that resulted into acquittal because that could not be substantiated. But point is that if anything is happening inside the bedroom, there will be no independent witness available, and statement of the woman has to be relied. And to what extent it will be relied, I think that our society is not mature ethically at that extent. That's why it should be delayed it should be put on hold for some time. Thank you.
Historical school of jurisprudence.
Sir,
Yes, sir. Yes, sir.
Because
Yes,
you know that Germany had also faced the same problem. What you said, that it must be delayed, as Germany advised the society regarding codification.
right, sir. Why German
Yeah,
code came in 1897,
yeah. It
almost
came
63 years.
around 50 years late.
Sir, sir.
Around 50 years late.
You
now
can say
Srishti Upadhyay.
more than 80 years.
Hmm.
Feminist was in 1814,
Hmm.
and the German code came in.
Oh,
Now Srishti Upadhyay, you ask question.
Good evening, sir.
Santosh sir, I am coming to you just after this question. Santosh sir, sorry. Srishti, now come forward.
Yeah. Good evening, sir. I'm Srishti Upadhyay, a first year law student of LC2. So my question is, we have been talking about laws being misused by women. So, sir, why instead of making other such misuse, why are we taking away those powers from women? That even the people who oppose the laws for marital rape say that women can take support of laws such as 498 IPC. But on the same hand, we are talking about even deleting that and taking away that power from women. So how can we justify this thing that we are going backwards and taking powers from the people who are genuinely facing the troubles? And this has been law is advancing day by day. So shouldn't law look into the matter of making other laws to prevent their misuse?
Okay, thank you, Sisti, for posing a very good question. We know that murders are committed with the help of firearm weapons. We stop manufacturing that. We know that sharp-edged weapons like daggers, knife, are used in cutting man. Have we stopped that? But if the thing reaches to that stage, now if you see the most recent incident which took place in America, that a person went on a small boys and killed 30 people there, including few teachers. Can we say that free selling of gun should be permitted by that society? Right now, the president of America has expressed concern against this kind of thing happening in America. But the point is that anyone can go and purchase gun at his own decision without any penalty, because the gun manufacturer lobby that is so dominant. Even Biden has said that the decision should put pressure on the manufacturers of arms and ammunition that they should go for less production. Point is that if we go to that extent of capitalism, this kind of thing is likely to happen. If man is more interested in money, devoid of any kind of sentiment and emotion, without caring extra for the of a man, start leveling false accusation against others, then certainly the weapon which has been given, it's, as I told you, that it simply creates a space. It gives an instrument in the hand of woman to exercise her right against the man. But once that is being misused, what you will do? Suppose your brother has picked up a cane or a hockey stick, and he is starting using against you to and fro. Now the question would be, how will you tackle that boy?
yeah.
You will take hockey back. Similar, if that reaches that extent, that it will be misused rather than being used properly, then what else will be the remedy? We can, sir.
Srishti, have you gone through about one, very landmark decision, Arnesh Kumar, one state of Bihar? You tell me why this pronouncement or why this landmark judgment was delivered by the Supreme Court. It is because of the reason of the misuse of the prevailing law. And that's why the Supreme Court has come out for the rescue of the society. And now there is, a little bit restriction regarding the misuse. But, now the police officers are going to face the inter-family, because there was, in case if we talk about the dowry, anti-dowry laws, etc., then what was being happened? Entire family was being, detained, and it was totally misused. But now it's the duty of the police officer, because of the reported guidelines down by the Supreme Court in Anish Kumar, that police officer has to think twicely before executing or before exercising the powers.
So that's exactly my question. They are taking precautions and they are doing being more vigilant rather than an harsh step. That's my question on that. Why taking away the law, instead of that we make some other laws that punishes the people who misuses such powers?
Sometimes that what is the job or purpose of the law? To have holistic balance. Because in case if we are beating the drums of marital rape, law for marital rape, then it will disintegrate the concept of family. And that's why, as sir said, that we are not fully mature. We are not fully, we are like, Savagani, that might be we are in nascent stage. We should not forget that when our independence and commence our constitution, because that no doubt we are going to cite the example of other countries, but again we should not forget our past, because our culturalization or civilization, our customary, because customary law also the importance of the right or wrong. So because what's the utility of historical school of jurisprudence? It integrates the society, it integrates the nation. Although sometimes that it gives birth to the nationalism, casteism. Right or wrong?
I would like to give you one example.
So that's why there has to be a balance between the approach of the jurisprudence or various theories of the jurisprudence. So here, that there has to be holistic balance with the interest of the side or act of society and the interest of the one sector of the society. What I'm understanding. And
yes, sir. Yes, you are 100%. More philosophically, I should say that if power has been given to anyone, that power should be used with care and caution. You must have heard the story of Bhasmasura. He was empowered by Lord Shiva that if he will put his hand on anyone, that person will be
power corrupts man, and absolute power corrupts
absolute power. Absolute. I'm not that. My simple religion is Bhasmasura. I'll tell you what happened. The person got all power that if he placed his hand on someone's head, that person will be burnt alive. And what happened? That power resulted into his own decay. So if the power is misused by anyone, which is not careful, cautiously, then that will be the cause of his own decay. That's why I am appealing that to this forum that power has been given by law has given space to women, and women should come forward to use where it is necessary to do so. Otherwise, there will be problem.
And moreover, it will take time. What I'm saying will be happen. Because as and when we will be educated, we are not educated. Once we will be educated, then there will be no need of this kind of laws. We are not educated because we are suffering from a little bit kind of outlook, and time will come.
Yes, Dr. Santosh.
Yeah. Thank you, Pramod sir. First of all, I would say my greetings and pranam to A.K. Pandey sir. Sir, you have taught me in BHU in 2004 batch. IPC you have taught me. I was there in BHU from 2004 to 2007, and now I'm the colleague of my Sri Motiwa sir. So first pranam to you. After a long time, I am seeing you, sir. And though I have raised here, say to some differ from you from your opinion on one point. Though I'm not the student of criminal law, I have done in international and other things. But to my limited understanding, please correct me, since I'm a student, always review a student if I'm wrong. The standard logic that I sometimes hear about the rights that law conferred about the vulnerable sections, and the logic that you have also given today that, okay, if power has been given to you and your power do not exercise properly, law could take back that power. So I don't think what is the basis of this, because I observe that CRPC evidence manuring skills to advocates. Advocates are using in day and night in the justice law courts to delay the justice, to delay all the kind of things. But there are no question arise that how to take it back, or wherever any question arise to take it back, reforms advocate as a group revolt. So when it comes to any other vulnerable person, that impose them as they need. They have suffered from like centuries or so many things. So turbulence may be there. They need it. And when he says that, okay, you are not exercising it properly, so we are taking back. Isn't it the responsibility of law, or cannot we put it in this way, that, okay, laws should be there, laws should take it, not the, it's that power is there and it's basically applied so that injustice should be protected. Instead of saying that in respect of all the vulnerable groups in the society, gender anyways, that you first empower them, then there's misuse happens. I know like many instances can be discussed here. The criminal justice system has been misused. All sort of judicial administration has been misused by men and dominant groups. But we're not discussing in those things, okay, change the power, change the legal system, or wherever there is effort of change from law commission reports or other reports, there is aggressive revolt or aggressive, what you say, that andolan from the legal fraternity and law practitioners. But it comes to women. That is why I am in support of what you are saying. We are the first women in this whole seminar that spoke about this. This is my point, sir. So whether it is right to say take it back or to make it more just so that injustice should not be done. Yeah.
The thing is that whatever is my statement is that should be taken in a perspective. At the time, the police has tremendous power to arrest a person with warrant. If there was a suspicion of involvement in a cognizable offense, police was involved. But that power has been taken, and another power has been conferred with restrictions. That if it is an offense below 7 years imprisonment, less than 7 years imprisonment, what it is more 7 years. So that unrestricted power from police that has been taken back, and a restricted power has been given to it. That was my concern. Second thing, that I am not saying that tomorrow it is going to happen. If it is being misused constantly for a longer period of time, and large number of persons suffering from it, then may happen maybe after 200 years. I am not giving any timeline or deadline. But that if power can be conferred, power can be vested, it can be divested also through the same process, provided the system remains. If we are having the state like which is in our country. That might not say that tomorrow it will be taken back. No, that has never been my intention. I am saying that if over a period of time it is observed that it is being misused more in comparison to its logical use, then certainly it may be given a thought. As having case of section 1 of the after DK Basu case. What happened?
Okay, sir. Thank you.
Yeah,
now,
sure, thank you, sir.
Kumar Shwetab. Last question. Let me introduce Kumar Shwetab. He's our batchmate into India 2005. We together with the law school.
I remember this name very clearly, so yes. I will not be able to recognize by his face.
Yes,
but
Shwetab,
Sure. Good evening, everyone. Sir, a lot of time has gone by. Big pranam to Akhlendra sir. Good evening, everyone. It was really good. After a very long time, we have heard Pandey sir. So it was a really very informative session. And sir, I have a very short point to just to ask. Sir, I have been, listening to you for a very long time this session. So what I conclude today is that the whatever mechanism the law is there framed by the legislature and shaped by again by Honorable Supreme Court, the responsibility to enforce it in correct direction and what as the aims and objectives of those laws and provisions rest on again majoritarian men. Those if we talk about the legal profession again, there are a very less number of women practice law. Similarly, in police also. So until and unless what I believe, the women are coming forward and joining these profession and services, this objective of framing these law will not be able to reach or achieve objectives. So, what do you feel, sir? Because I have observed, is personally also being in this profession for 17 long years, that simply if a woman goes to lodge a complaint before an pretty advocate to take legal help, what they do not go by exactly the complaints which she is having. They try to frame as per the existing practice, whatever point are not there, they will incorporate it just to defend her case. Similarly, police also goes extra mile to due to their own motives and beyond law. So how we can control that, because they may not be aware. Women, in metro cities, I can understand that they can understand the consequences and they can follow the things in a well-mannered thing. But for the women residing mostly in areas and small towns, so responsibility to enforce these laws are still on men. So can we conclude today?
Yes, sir. Now, sir, answer your question.
Okay. Please, sir. Please, sir.
If I could get your question in right perspective, what you are suggesting is that what should be done so far the enforcement part is concerned. One thing should be very clear in our mind, that law is not partial. Law is one of the several instruments which society is controlled.
Yeah.
There may be family control, social control, legal control, religious control, ethical control, so on and so forth. Law is one which is enforced through the state machinery. All others are not enforced through the state machinery. So first thing is that unless until there is consciousness raising in the society, it is very difficult for any society to implement the provisions of law. Number one. Number two, that if I take the example that there was a time when a child growing in the fetus, if she was found, if it was female, then she was destroyed and terminated. But the cases of such nature, that is coming down. So with the evolution of society, with the new views in society, ultimately we learn in this process. You cannot cause any person to learn by showing force and coercion. It should come from within. If it is coming from within, then law will lose its significance to a great extent. So my answer to your question is that it is a process. Law is a learning process. Let society grow, gradually pick up new values, accept values. That's why And in that manner, we can enforce the process of
Yes,
Thank you so much, sir. Thank you so much.
Thank you, sir.
Thank you, sir. Thank you.
Thank you, sir, for answering all these questions very nicely.
Thank you,
and
sir.
very-
Thank you so much, sir.
Thank you, sir.
Now this is the time for
Thank
vote
you.
of thanks, because this is the formality of the program. The program should end with the vote of thanks. That is, I am taking the opportunity to express my sincere vote of thanks to you, sir, at this occasion. Now, very outset, on behalf of the Faculty of Law, Law Center 2 Faculty of Law, University of Delhi, I express my very heartiest thanks to you, sir, for coming with us to this late evening and enlightening such a vibration to students this juncture. So, Law Center 2 is very thankful to you, sir, to grace this occasion and to accept our invitation for addressing our students in this late evening. So thanks a lot, sir. Thanks a lot. You have given the meaning of feminism in the very beginning of your program, and you have said that this is originated from medical science. That also provoking and mind blowing, sir. Actually, I was not aware with this particular thing. You have also taken up too many facets and varieties of feminism, particularly liberal feminism, classical feminism, Marxist feminism, postmodernism. You have given a lot of knowledge of concept of feminism to the student at this chair. So that also means enlightening session. Last but not the least, you have given the feminist justice concept with very wide way, which was not even learned to us at through book. We cannot gain this knowledge by reading the book. So that is why we are thankful to you for enlightening this son in vibrant, informative way. We have also connected the feminist justice together with the too many leading cases decided the Supreme Court of India, including Saira Bano and that is Sabrimala and all. So in this way, you have connected the feminist justice together with all these leading cases which has been decided the Supreme Court of India. It was also very knowledge, very vibrant for our student, and particularly being the member of legal fraternity for us. So that is why with this note, I am expressing my warmest and very heartiest thank on behalf of Law Center 2 Faculty of Law, University of Delhi to you. And my pranam to you, sir, also because you are my guru at LLB, at LLM. I complete my dissertation. You are super, and you have given me a lot of knowledge. For women, I was in present, sitting in class, and you were teaching penal code and that was the impression for a few moments to me. So that was very interesting and very emotional event for me also in today event. So thanks a lot, sir, for being enlightening for this and to us. Thanks a lot.
Thank you, sir. Thank you, sir.
Now my sincere thanks to our beloved professor in charge, Professor Dr. Mahavir Singh Kolon.
Thanks.
Professor, Law Center 2 Faculty of Law, University of Delhi. He is always ready and willing to assist us and encourage us to arrange program at very frequently. And particularly, let me take you in the Golden Jubilee celebration of Law Center 2 and century celebration of University of Delhi. We are organizing such an event very frequently. Means a lot of and wonderful program has been organized. But this program is one of the most I think knowledge-wise very vibrant program, I think. I also express my heartiest thanks to program director, Professor Dr. Pinky Sharma Madam, who is always ready and willing to assist us and encourage us to organizing such an event. My express thanks to all the organizing faculty member, Dr. Saurav Rananji, Dr. Belu Gupta Madam, Dr. Aswani Siwal, Dr. Saraswat, Mr. Anand, and others. This is also by the operation of these colleagues we have organized this wonderful program. My heartiest thanks to all the colleagues and all the alumni of Banaras Hindu University Law School, particularly Kumar Shwetab, Dr. Santosh, Nirbhay Shankar Tiwari. He is one of the very famous, very renowned advocate in Supreme Court of India, also program minutes before, sir. So too many alumnus of Law School Banaras Hindu University were there in this particular program.
I think Dr. Amarendra is also from BHU.
Dr. Amarendra,
yes.
Asukinath Dubey, Dr. Sehwal Satyarthi, so all those persons were there in this program. In evening service, they are teaching in Center 1. So they are limited. Although they joined the program few hours and few minutes. So they have also here to listen you, to see you, to darshan you, and to take blessing of you. So that was very means. This is my sincere thanks to all my dear alumnus of Law School BHU. My sincere thanks to my dearest student of all the three center of Faculty of Law, including Center 1 Law Center 2, Campus Law Center. So many students were there from all the three centers in this program to listen you, sir, and they were very eager to ask the question and listen you in this program. So my sincere thanks to all the students who have joined over here. My sincere thanks to all the stakeholders, particularly the technical Dr. Sonavane. He was one of the colleague of mine. He is assisting a lot for us for the entire program. Sonavane, sir, many thanks to you. My sincere thanks to all the colleagues, all the teachers of Law Center 2, Law Center 1, and Campus Law Center, all the students of all the three centers, and other stakeholders of legal fraternity. My thanks to you all for coming to the program. Thank you, sir. Thank you a lot, and come to you, sir. Thank you, sir. Yeah, I see, sir. Now may I declare this program closed now. Okay, thank you all. Thanks. Thank you all. Thank you.